What the court file teaches us, public records cases, and practical lessons for owners. Hello, yet again. This is Forrest Owens. I'm an aviation lawyer, a private pilot, and an FAA licensed airframe and power plant mechanic. Finally, let's discuss what the public court files teach us. Because aircraft appraisal mistakes become easier to understand once you know how they're litigated. The first example is Bombardier Aerospace Corporation versus SPEP Aircraft Holdings, a Texas case involving a Challenger 300 sold as a new aircraft. The dispute centered around undisclosed engine history and the resulting claim that the aircraft was worth less than what the buyers had paid. The plaintiffs presented an aircraft appraiser on diminution of value. Bombardier presented its own appraisal expert. What makes this case important is not only the result, but the lesson. Valuation litigation in business jet cases often turns on maintenance and disclosure facts that non-lawyers treat as secondary. The court recognized that aircraft appraisal testimony on value can be sufficiently grounded even without a simplistic bright line formula, especially where the opinion is tied to the aircraft's actual condition and history. This is the first memorable lesson. On a turbine jet, appraisal fights usually begin as disclosure fights. The second example is Aircraft Holding Solutions versus Learjet, a Fifth Circuit matter arising from damage to a Challenger 300 while it was stored at a Bombardier facility. The valuation record in that case is especially instructive because it shows how damage, maintenance status, and subsequent sale data can adjust a valuation story over time. One expert valued the aircraft before the incident at roughly $6.7 million, estimated a materially lower value after damage and maintenance due exposure, and then later considered subsequent sale data showing a later sale at a much higher number once the aircraft had been restored to a marketable condition. That sequence is exactly why aircraft owners need to understand the valuation date. The aircraft did not have one eternal value. It had different supportable values at different moments because the facts had changed. Here is something to remember and keep in mind. When it comes to aircraft appraisals and the law, the date matters almost as much as the damage. The third example comes from the tax context. In Eisen versus Commissioner, the Fifth Circuit affirmed denial of aircraft charitable contribution deduction because the taxpayer failed to satisfy the governing substantiation requirements. The teaching point here is memorable because a taxpayer may sincerely believe an aircraft was worth the claimed amount. That belief is not enough. In regulated valuation setting, the law cares about compliance with the appraisal and substitution rules, not merely what the number sounds reasonable, if the number sounds reasonable in hindsight. The fourth example comes from property tax litigation involving business jets. In Jet Sales West, the bankruptcy court recounted how local authorities appraised the company's jets and assessed tax based on the appraised value. Whether one agrees with the tax results or not, the case demonstrates a practical truth. Aircraft value will be assigned by someone. If the owner does not build a credible valuation record, a taxing authority, counterparty, or opposing expert will often build one for them. There's also a broader lesson from public records disputes involving business aircraft. Appraisals are only as strong as their factual foundation. Cases repeatedly expose the same pressure points: missing or incomplete maintenance records, unclear damage history, weak comparable selection, over-reliance on generic market guides, failure to account for engine program status, failure to tie the value opinion to intended use, and failure to update the valuation after material events such as inspection, repairs, component overhauls, title issues, or market disclosure. A recent commercial example outside the damage context makes the same point from another angle. In Jet Experts versus Asia Pacific Aviation, the courts dealt with a Challenger 300 purchase dispute and heard detailed testimony about what made the specific aircraft unusually valuable for the buyer's mission: low hours, overhauled engines, completed inspections, a three-piece divan, a FAA-approved medical use characteristic. Whether one calls that an appraisal issue, a unique issue, or a specific performance issue, the lesson is the same. Aircraft value is intensely fact-specific. Comparable aircraft are only comparable if the important facts really compare. That is why I advise aircraft owners to think about appraisals in 3 files, not one. File 1, the factual file: records, damage history, program status, configuration, title, and current condition. Fact 2, the assignment file: intended use, valuation date, standard of value, scope of work, and assumptions. File 3 is for the defense file: the documents you would want if the IRS, a lender, a court, an insurer, or a buyer later asks, "What do you believe the aircraft was worth?" What is that amount? The practical strategy is straightforward. Use an appraiser with aircraft-specific competence and turbine market familiarity. Match the assignment to the legal or business purpose. Insist on meaningful records review. Distinguish a desktop indication from an inspection appraisal. Update valuation after diligence or major maintenance events, and never let the aircraft's appearance substitute for its documented reality. Here's something to remember. In large turbine ownership, a bad appraisal does not merely produce a bad number. It produces bad decisions, and those decisions become expensive when the file is opened by a lender, a taxing authority, or a court. Aircraft appraisals matter because they sit where value, evidence, and credibility meet. On high-value turbine aircraft, that intersection is too important to treat casually. In short, the importance of aircraft appraisals is not that they tell you what you want to hear. It is that when done correctly, they tell you what can be defended. Here is the takeaway line. On a large turbine aircraft, the best appraisal is not the highest number. It is the number that survives scrutiny. Thank you for your interest in this topic. This information is provided for informational purposes only, and it should not be construed as legal advice. Please direct your questions, and those questions are very welcome, to admin@aviationlegalcounsel.com. We look forward to helping you navigate these questions with precision.